All right, this is just We the People News. Not an attorney, not giving legal advice. Educational purposes only. Okay? Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Now, this is going to be a lawsuit which uh, Eddie Craig is dissecting to see what they need to do to clean the lawsuit up. Okay? And it's due to, some of these judges acting in dishonor and wanting to issue what, and it can be a cop, and it can be all any government bodies. Okay, it doesn't have to be particular who. This case, it to a bad uh, a judge with unclean hands. Okay, um, so we'll just dissect and check out the good and the bad on this, but it gives you an idea that you can sue them. Okay, and win or lose, they start to get a little nervous about being sued all the time. Just saying, you know, they got to stay on their toes that people actually start suing them. But this is more of a suing to get an arrest done with some of these judges or cops or whatever. Okay, so that being said, some people have a hard time understanding uh, jurisdiction, subject matter jurisdiction, and personal jurisdiction. The easiest way to explain this, of course, this goes into many different categories, but for instance, there's a law that says you can't kill nobody. Okay, that's the subject matter. You know how to do it. All right, and when you go kill somebody, that's the personal jurisdiction, and they have the court and put you in jail because they have subject matter jurisdiction and personal jurisdiction. Now let's just say, for instance, uh, same thing, right? You got the subject matter, which there's a law saying you can't kill somebody, but you did not kill that person or anybody. Okay, well, that right there, they don't have personal jurisdiction. So without that personal jurisdiction, they cannot have that in rem jurisdiction. So when they say you got to have both, it's because there's got to be a law there, or in this case, the statutes and all this kind of stuff, and that must actually apply to you. All right. For instance, some of these things about um, la, 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 the right to travel. Okay, I know it's controversy, but look at it this way: if there's a law saying you have to have a driver's license, and you go get your driver's license, you show the officer the driver's license. That gives them personal jurisdiction. Okay? Then you can argue your case whether you're in commerce or not. Okay? Now, when you back up, if there's no law saying that you have to have a driver's license to travel, right? Um, then there's no subject matter. Okay? And this is what everybody's saying, that you don't have to have a driver's license, this, and this, because there's no law saying I have to have one, right? It's a different four corners to be operating in, okay? Supreme Court actually, I can't remember the case number, but everybody keeps going by that one, but they don't break it down in two different deals. The judge gave us remedy. It had two outcomes. It had the private, where we had rights to go ahead and have to travel in our private property. But also in that same category, there was a man that wanted the privilege and was denied. All right. He wanted to be a truck driver, but maybe there was something that happened and the state says, no, we're not going to give you this privilege. You're too dangerous. So they denied him. Well, since it's a privilege, they can deny him. But since it's a right and we don't need a driver's license, they can't tell us we couldn't drive our private property because we're not in commercial. So that right there is going to be the subject matter jurisdiction and the MREM jurisdiction right there. It's the easier way to explain it for some of y'all, okay? Of course, it goes into many different categories, but that's the easiest way. All right. There we go.
Randy's got a new short lawsuit he wants to file when these judges don't do something they're supposed to do. And I'm not really sure. Why does he have this all in 14 size font? Who the hell knows? Okay. In any case. Alright, so we're going to try to go through Randy's lawsuit here, his new one for these judges real quick. Alright, can everybody see this? Introduction, plaintiff was harmed by defendant. Okay,
Yes.
Now, Randy wants to use this, I presume, against judges who won't take and file warrants when you file a criminal complaint. So, let's see what Randy's trying to do here. And a second, sorry. One dog goes off, they all go off. It's like a bad alarm system. Plaintiff was harmed by defendant, consequent to the refusal of defendant to perform an administrative duty placed on defendant by the swearing on his oath to protect the Constitution. A. Failure to perform a ministerial duty. Plaintiff, as a citizen in this republic known as the state of Texas, before allowing defendant to take public office, as a covenant of the contract for payment of services, demanded that plaintiff swear on his or her oath that defendant, he's got this shit written completely backwards. It's not plaintiff, Randy, it's defendant. Demanded that defendant swear on his or her oath that defendant would uphold the laws of the state of Texas. Defendant failed to perform in compliance with said oath by failing to perform an administrative duty by refusing to issue a warrant against a person accused of a crime. Said refusal was in direct violation of Texas Code of Criminal Procedure 15.09, which reads in pertinent part as follows. And we've been through 1509 already. Complaint may be forwarded. A complaint in accordance with Article 15.05 may be forwarded as provided by Article 15.08 to any magistrate in the state, and the magistrate who receives the same shall forthwith issue a warrant for the arrest of the accused, and the accused, when arrested, shall be dealt with as provided in this chapter in similar cases. B. Shield from prosecution. Said refusal to perform under defendant's contract with the state had the effect of shielding the accused from prosecution in violation of Texas Penal Code 38.05A2, which reads as follows. 3805, hindering apprehension or prosecution. A2, provides or aids in providing the other with any means of avoiding arrest or effecting escape. C, official oppression. I gotta talk to Randy about how he does this shit. Defendant also violated, Texas Penal Code 39.03, which reads in pertinent part as follows. Official oppression. Okay, again. Constitutional protection. Said refusal on the part of defendant to perform an administrative duty had the effect of denying plaintiff in his or her rights in violation of the Texas Constitution, Article 1, Section 3, which reads as follows. That in general, great and essential principles of liberty and free government may be recognized and established, we declare equal rights. All free men, when they form a social compact, have equal rights, and no man or set of men is entitled to exclusive separate public emoluments or privileges, but in consideration of public services. Equality under the law. The equality under the law shall not be denied or abridged because of sex, race, color, creed, or national origin. This amendment is self-operative. Said failure further disenfranchised plaintiff in violation of the Texas Constitution, Article 1, Section 19, which reads as follows. Deprivation of life, liberty, property, etc. by due course of law. No citizen of the state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disenfranchised except by the due course of the law of the land. Repudiating contract. Said misfeasance in office had the effect of repudiating defendant's contract with the state and the failure to provide plaintiff in the procedural due process of the laws of the state of Texas, harming plaintiff thereby. Okay. Statement of facts. File complaint. On the date, complainant presented criminal complaints against the name wherein complainant accused said official of violating a law relating to his or her office. B. Failure to perform. Said complaint was complete in accordance with Texas Code of Criminal Procedure Article 15.05, which reads as follows. Requisites of a complaint. Defendant failed to perform his or her duty as prescribed by Texas Code of Criminal Procedure 15.09, which reads as follows. 1509, complaint may be forwarded. Already read that. By the above, the legislature, on passing Texas Code of Criminal Procedure 15.09, the Texas legislature prescribed a ministerial duty upon magistrates in the state of Texas. That's the only correct thing you said so far. Statement of claim. Courts in Hartford, Connecticut recently addressed the abuse of power by government as follows. The law limits the power of the good lest the wicked inherit it. Till recently, most of us have believed that the checks and balances within our legal system require no attention to keep them running smoothly, but recent events have undermined that confidence. Faith that government's three great gears, the executive, the legislative, and the judicial, are self-calibrating has been seriously undercut by a pandemic and by violence from the right and the left. The above is a wonderful read for anyone concerned with the excesses of government during times like these, when the best people with the highest of motives wreak havoc from the noblest intent. The above notion was adroitly addressed by H.G. Wells in his outline of history on speaking of the excesses of the popes during the Dark Ages. He very aptly observed, the giver of the law most owes the law allegiance. He of all beings should behave as if the law compels him. But it is the universal failing of mankind that what we are given to administer, we promptly presume we own. Misfeasance in office. When plaintiff presented criminal affidavits to defendant who refused to perform his or her duty as prescribed under Texas Code of Criminal Procedure 15.09, why is he telling the judge super means previously cited? Good Lord, Randy, what the fuck? Defendant failed to perform a duty. Defendant was commanded to perform and, in the process, denied plaintiff in the full and free access to and enjoyment of the right to procedural due process of law in violation of Texas Penal Code 39.03. And again, official oppression. I don't know what the fuck he's doing here. By failing to perform the duty prescribed by Penal Code 3903, there is no fucking duty prescribed there, Randy. It's a penal statute. For the love of God, man.
So for this right here is basically what did statutory construction in a different type of way, but it's the same principle. He's kind of breaking it down like, oh, nope, this is incorrect because it's been misread, misunderstood.
By failing to perform the duty prescribed by 3903, he was in direct violation of 39.03. Well, that would always be the case. But the thing is there is no duty under 3903. 3903 is all about the breach of the duty. But once again, don't use this fucking lawsuit, people.
Explain how, I'm kind of not seeing it.
Seeing what?
How, what he's done wrong. I'm not.
What, who's done wrong? Randy or?
Yeah, Randy.
Well, for one thing, he hasn't cited anything that's a valid claim, okay? He keeps citing, he's saying a duty to perform under 3903. There is no duty to perform under 3903. 3903 is strictly punitive, okay? It's 100% punitive. That's 3903 right there. There is no duty under 3903. The duty is elsewhere.
I see what
Like
you're saying.
1509, for instance, which is what that should say, okay? By failing to perform the duty prescribed by 1509, then he became an offender under 3903.
I see how you. Okay, I see it.
Randy always says, I want you to tear it apart. No, Randy really does not want me to tear this shit apart. He just doesn't. Shielding from prosecution. Further, by refusing to perform his statutory duty, defendant acted to shield the accused from prosecution in violation of Texas Penal Code 3805, which reads as follows. At trial on the merits, plaintiff will show defendant acted under color of his or her official capacity. Said act was an act in furtherance of a long-standing practice of magistrates refusing to issue warrants when complaints are filed by private citizens against public officials. The failure of the magistrate to issue a warrant upon being given notice of a crime was in direct violation of the statutory mandate contained in Texas Code of Criminal Procedure 15.09 Super. Defendant's actions suggest that the persons named in the complaints filed by plaintiff again, not properly written. See, defendant's actions suggest that defendant's intentions were to shield the persons named in the complaints filed by plaintiff from prosecution in direct violation of Texas Penal Code 38.05 Super. Duty to know the law. It must be construed that defendant acted with full knowledge of the impropriety of his acts as construed by the United States Supreme Court in Screws et al. Okay, which
All right, we're gonna go ahead and pause there because it's actually kind of pretty lengthy, and so it's gonna be different parts. I'm gonna do this one tonight, and tomorrow maybe do the next one. But if you want the whole content of this, same one I did last night, same YouTube channel, Pro Se v Court. Okay, and again, don't be using this, but it gives you an idea of what they're doing, and at least he's trying something. People, we need to put these people back in check. Okay, so in the state of Texas, there's a statute saying that small claims is up to $20,000. Problem: the state constitution goes only up to $200 with the JP. Okay, so the statutory of 20,000 violates the state constitution. It cannot be more than 200. Now, that being said, if he's going after the government body, the magistrate, cops, and all that, needs to nitpick that. Okay. Now, if I go sue somebody, that don't know law, or an attorney, I could take that chance. But if I know somebody that I'm suing or anything like that, then it must only be in GP up to $200, or I'm going to have to go to a higher court if I want to sue even more. Okay? And since he is going after a magistrate, issue warrants due to his criminal complaints, he needs to be nitpicky about this. Especially if the magistrate, so-called judges, know the Constitution, state Constitution. So the state Constitution says $200. Cannot be more than $200. But the statute went up to $20,000. That's unconstitutional on its face. Okay? Don't benefit us. That kind of sucks, They need to rechange the Constitution, have a constitutional convention, and up it. But because nobody knows this, why do they have to change the Constitution? We'll just go by the statutes and keep breaking the Constitution. Violate everybody's rights. If you're being sued $20,000, they just violated your rights. All right. This is We the People News. Bye, y'all.